They are not.
What happened to the other?
Okay, there we go.
We don't need a nollie for this. It's on a citation, Mr. Martinez.
Oh, my apologies, sir.
No. On the record in the matter of the people of the state of Michigan versus Linda Evans, 24-01768.
Your Honor, subpoena almost we are requesting permission to practice under MCR 8.120 under the supervision of APA Joe Martinez for the people.
Commission granted.
Jacob Riley on behalf of Ms. Evans.
Okay, today's the date that was set for final pre-trial for assault and battery. Let's see, do we have witnesses here?
Your Honor, the witness showed up, got irritated and left.
Okay. Are we continuing to trial?
Yes, Your Honor.
This matter is scheduled for trial, let's see, September 3rd. Tell us that we're calling you. I thought they blocked it that week. The day after Labor Day. I was waiting until the final pre-trial stage. Yeah, because we did. Okay, we need to reset that date because I don't think we're following Jerry that week. September 17th. September 17th at 8 a.m. Do you have any questions for the court today, ma'am? No. Additional matters for the record, counsel.
Nothing for the people, Your Honor.
No, Your Honor.
Okay, we'll get you a notice to appear. The record in the matter of the people of the state of Michigan versus Louis Figueroa, file number 24-01591.
Okay, sorry for the people.
Jacob Riley on behalf of Mr. Figueroa.
Okay, today's the date that is set for final pre-trial, matter scheduled to proceed to jury trial on count of assault and battery. Do we have witnesses here?
One moment, Your Honor. We're just making one last check. So,
Counsel, how do you want to proceed?
Defense would request dismissal, Your Honor.
Motion to dismiss is granted without prejudice. The people have the right to reissue the charge against you, sir. You understand that? Any questions? No. It's your copy of dismissal in just a moment. You're all set.
Yeah, my baby, yes.
Sit down.
Yeah, just go away.
On the record of the matter of the people of the state of Michigan versus Elijah Juan Granberry, file number 24-01554. Counsel appearance.
subpoena almost on behalf of the people.
Jacob Riley on behalf of Mr. Granberry.
Place the date that's set for a final plea trial. Matter is scheduled to proceed to jury trial September 10th. My understanding is it's going to be approved today.
That is correct. There's one issue we're going to discuss with council. before we proceed.
My baby. Get me out of here.
Okay, so I do have a plea sheet that says the people are offering for you, Mr. Granberry, to plead. To plead guilty to an attempted resisting obstructing, and they will dismiss the assault and battery. And then there's no objection to a sentencing agreement of no upfront jail. That's complete and accurate.
Yes.
You want to accept that, Mr. Granberry?
Yes, Your Honor.
Okay, raise your right. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, you can put your hand down. This is an advice of rights, 2 pages these days. Is that your signature?
Yes.
Could you read these rights?
Yes.
Do you understand the rights that are listed here?
Yes, Your Honor.
Do you want to give these rights up in order to accept the plea offer?
Yes.
Okay, so that means you're gonna give up your right to the presumption that you are innocent. So you're innocent until proven guilty. And you have the right to require that the prosecution prove your guilt at trial. You have the right to a jury trial, and you can remain silent at that trial and not have silence be used against you. You have the right to confront in court and cross-examine any other witnesses that they intended to call against you. You have the right to call your own witnesses to testify for you at your trial on your behalf. You can waive your right to silence and testify yourself. You understand all those rights?
Yes, Your Honor.
Are you willing to give up that presumption of innocence and the trial rights to enter a guilty plea?
Yes, Your Honor.
Is anybody threatening you to get you to do that?
No.
Any promises being made in exchange?
No.
For you entering a guilty plea? Are you currently on probation or parole?
No.
You understand that a guilty plea could result in a conviction that you may need to report to your future employer or to a current employer.
Yes.
It could also have impact on what countries you can travel to or immigration status that you may be seeking.
Yes.
As to count 1, attempted police officer assaulting, resisting, obstructing, how do you plead?
Guilty.
Is that because you believe you're guilty?
Yes.
Factual basis, please.
Mr. Granberry, on or about May 25th of 2024, at or near the location of 6100 South Seaton,
Yes.
Zion City, Lansing, in every state of Michigan.
Yes, sir.
While at that location, you have contact with police.
Yes.
Police inform you that you were under arrest.
Yes.
They order you to place your hands behind your back so that they could handcuff you and place you under arrest.
Yes.
Is it true that as they were attempting to place handcuffs on you, you pulled away and tried to like
Yes.
they had a lawful reason to arrest you?
Yes.
Any questions for the prosecution?
Satisfied with that.
The court is satisfied with the factual basis. I'll accept your plea if I to be free, voluntarily and intelligently made. Matter is set for sentencing October 1st at 9 o'clock in the morning. When you leave here, you're gonna go down one floor to probation. Check in with them so that they can prepare you for a pre-sentence interview. So they can create a report advising me as to how they believe you should be sentenced, okay?
Okay.
Do you have any questions at this time?
No.
Any additional matters for the record, counsel?
Nothing for the people.
No, Your Honor.
You're all set. Who's representing Mr. Nance?
That would be me, Your Honor.
You ready to proceed?
No, Your Honor.
On the record of the matter of the people of the state of Michigan versus Troy Nance, file number 23-03436. Council appearance.
Kena Almosawi for the people, Your Honor.
Rally on behalf of Mr. Nance.
Mr. Nance, can you hear us?
Yes, Your Honor.
Next date's up for pretrial. It's for a domestic violence charge. Was there an offer on this?
Your Honor, we did not have one as we have not been able to get in touch with the victim. We have called multiple times, sent emails, and sent mail as well. She is showing on the video right now. So I guess we can try and offer one on the spot right now.
What, did you need to speak with the victim before you could do that?
I'm guessing, but as for her, she has sent multiple letters asking us to drop the charge.
What's the offer?
Your Honor, at this time, the defense would request a second pretrial conference so that I can discuss the offer with my client and make that not disturbed.
I asked what the offer was. I'm waiting for it to be stated on the record.
Yes, Your Honor, the people's offer was for disorderly jostling instead of the DV. That would also give us time to speak with the victim as well.
Okay, you said she hasn't been responsive to your phone call?
No, no phone calls, no email, and no mail.
Nance, can you hear us?
I'm sorry?
Hear us in the court? I'm assuming you can.
Yes, I can hear you.
Okay, did your phone number change?
I'm wondering if I have a different number. It hasn't changed for quite a while.
Okay, well, you
Because
hang tight.
I haven't gotten
Excuse-
any
ma'am,
phone calls.
Ma'am, you hang tight. When we're off the record, I'll have the prosecutor log in to talk to you privately, make sure that she has the accurate number for you, and make sure she has an accurate email address for you, because for the prosecutor's office to be receiving letters, and the court has also received a letter or communication from you, it's interesting that you wouldn't be responsive to their contact. So let's make sure everyone's on the same page as it relates to that. I'll get you another court date for pretrial, Mr. Raleigh, for your client.
Thank you.
August 27th at 10:30. August 27th at 10:30. He'll still be in the custody of Charlevoix. Is that correct?
I believe so, yes.
Any additional matters on today's record for this?
Nothing for the people.
No, Your Honor.
No,
Mr. Nance, you're all set.
thank you.
You're welcome. And I'll put her on a private. Okay, on the record in the matter of the people of the state of Michigan versus Stephen Robbins, file number 24-01609 and 610, Council Fields.
Hannah Almosawi for the people, Your Honor.
Morning, Your Honor. Sean Campbell on behalf of Mr. Robbins. Mr. Robbins, the room.
Today was the date set for a final pre-trial, however, I have now that indicates that there were, resolution was a dismissal of the destruction of property charge and a civil infraction on the dog at large. Is that accurate?
Your Honor, we actually ended up dropping it to a civil infraction of impeding traffic for,
Right.
so we dropped, yeah, we dropped both and went down to impeding traffic plus restitution.
Because there's no civil infraction of dog at large, but nonetheless, what's the restitution amount?
It's $2,608.33.
Is there an objection to or dispute as to restitution amount?
No, Your Honor.
Yes. Okay, impeding traffic is $135. Is he paying today?
Yes.
There's restitution that will be ordered in the amount of $2,608.33 to John Turner. When is he going to say that?
Okay.
We'll get you over to the criminal traffic window and you'll be all set after payment is made. Thank you.
So,
Thank you.
Thank you, Don.
Okay, on the record in the matter of the people of the state of Michigan versus Michael Thomas, file number 23-01315. Council appearance.
Hannah Almosawi on behalf of the people, Your Honor.
Jacob Rowley on behalf of Mr. Thomas.
Okay, today was the date set for a jury trial. There was some back and forth on this, I think via email, about whether or not we were proceeding to trial. I indicated that this was set for trial, so we're expected to continue to a trial. I think the request that I originally heard was that there was going to be a motion for a nollie and a reissue. And I want to address an email that came back in reference to that and the judicial authority over that. There's a limited scope in which the court can deny a nollie if they believe that there's malfeasance. I hold final pretrials. I hold multiple pretrials. I have no record of there being an offer on this. And an offer would even include that there was an offer to not reissue. And so if that was the offer, it should have been stated on the record. And had that been communicated even then that would indicate to the court that there is no harassment from the prosecution side towards the defendant. And so if I set it for trial and expected to go to trial and there was a final pretrial, we could have done the dismissal at the final pretrial stage if he wasn't willing to take the offer, rather than hold up the trial date. Why are you speaking when I'm speaking? Why are you speaking? I'm talking to you. But why are you speaking over while I'm speaking? Thank you.
I just feel like it's a lot of confusion between me and the lawyer.
There may be confusion between you and your lawyer, but I'm not talking about your confusion between you and your lawyer. That's not what I'm talking about. I'm clarifying some email exchanges. You can continue to talk over me and then we can handle this a different way. I'm talking about clearing up some back and forth about the trial date. there was clarification as to, that there was an offer that was previously communicated?
Yes, Your Honor, with our issues, unfortunately, yes, I believe we never had them on the record. I wasn't the one on these,
I didn't
but
recognize that.
yes, so for my end, based on the emails I've had and the notes that our office has, the offer has been on the table since June of 2023, the same exact one from the beginning. We offered that it's either they take the amended charge or that we go back to the RNO in circuit court.
Take the original charge?
Exactly, yes.
Okay.
For the amended charge, what we charged was the amended charge, basically. So that was on the table from the beginning. After conversations last week with the defense attorney, we came to a deal of disorderly jostling, which we had to wait for the officers to agree on. And once that agreement came in, and after the email about the time served, we decided that the plea agreement would also include the time served.
So the offer is, so it's originally charged as attempted police officer assault.
Yes.
But I'm trying to understand, is the offer was the original offer to?
The original offer was
To charge it as a felony?
To plead as charged.
Or really
or
charge as a felony?
Yes.
Got it. And then through further negotiations, it went down further to?
All the way to disorderly.
Disorderly, got it. And Mr. Raleigh, you were aware of those offers, correct?
When I received them, yes, which they did change.
When you received them, what does that mean?
In other words, I received the, I guess you can call it an offer of plea guilty as charged or recharge as a felony. And I think at one point it was stated that there was no offer.
That's what I have as of July 2nd.
You never say it on the record here. So that was my understanding at the time. So last week, communications resumed and we were able to negotiate further.
Okay, so what is the offer now?
Disorderly jostling with credit to time served.
What does your client want to do? Does he want to have time to think about that, since it sounds like he was confused? Does he want to proceed to trial?
Frank, he does still have some concerns and confusion. We could have another court date with some finality. With that offer locked in.
And just for the clarification for the court and for the defendant, if he does not accept this offer, the alternative is to have this case charged as a felony, correct?
Yes, Your Honor.
Okay, he's clear on that?
Yes, sir.
I'll set it for final pre-trial.
Thank you.
August 27th. 27th at 8 a.m. Do you have any questions, Mr. Thomas, today for the court?
No. No, Your Honor.
Okay, we'll get you a copy of your notice to appear. Any additional matters for the record, counsel?
Nothing for the people, Your Honor.
Your Honor, was that 27?
27, yeah.
Thank you. No, nothing further from this.
Thank you. You're all set. We'll get you your notice. Someone's in county jail.
If I'm able to talk to you first, I'm every Friday.
No, it's happening here.
Honor, we do have a witness in the jury room. Can I dismiss her?
Okay. And we'll talk with you there.
Okay, on the record of the matter, the people of the state of Michigan versus John Heather, file number 24-01274. Council appearance.
Your Honor, subpoena Almosawi on behalf of the people.
Jacob Riley on behalf of Mr. Heather.
Okay, today was the date that was set for pretrial, and it's for retail fraud, third degree. Our last court date negotiations were pending. Is there an offer at this time?
Yes, Your Honor, the people have offered Mr. Heather an attempted retail fraud third with no upfront jail.
And my client has opted to accept an offer. I can present the paper, the agreement.
Thank you. Okay, let's see, Mr. Heather, is that accurate that you want to plead guilty to an amended charge of attempted retail fraud, third degree?
Yes, Your Honor. Yes, Your Honor.
Okay, please raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
You can put your hand down. So, Mr. Heather, you have the following rights that you would need to understand and then that you would need to give up if you want to accept this offer. You have the right to be presumed innocent until proven guilty. Do you understand that?
Yes, Your Honor.
Are you want to give that right up, sir?
Yes, I do.
You have the right to proceed to a jury trial. You have the right to remain silent at trial and not have silence be used against you. You can waive your silence at your trial and testify on your own behalf or subpoena witnesses to give testimony for you at trial. And you have the right to see, hear, or question any other witnesses that the prosecution calls to testify against you. You have the right to have them prove each element of the charge being brought against you beyond a reasonable doubt before you are deemed guilty of the charge. Do you understand those rights?
Yes, Your Honor.
And you're giving up each of those rights today?
Yes, Your Honor.
Is anybody threatening you to get you to do that?
No, Your Honor.
Any promises being made to you in exchange for a guilty plea?
No, Your Honor.
Are you currently on probation or on parole?
Yes, Your Honor.
You're on which?
Probation in Eaton County.
And you understand that a guilty plea could have impact on your probation status?
Yes, Your Honor.
Okay. And you also understand that if you plead guilty, it can result in a conviction that you may need to report to a current employer or a future employer.
Yes, Your Honor.
Lastly, a guilty plea could have impact on travel or immigration status that you may be seeking. Do you understand that?
Yeah. Yes, Your Honor.
As to the amended charge of retail or attempted retail fraud, third degree, how do you plead?
Guilty, Your Honor.
A factual basis, counsel.
Thank you, Your Honor. Mr. Heather, on or about March 23rd of 2024, were you present at a Meyer store at 6200 South Pennsylvania Avenue in Lansing?
Yes, I was.
And is this in the city of Lansing, Bingham County, state of Michigan?
Yes, it is.
While you were at that store, did you take some items off of the store shelves that were offered for sale to the public?
Yes, I did.
Did you conceal those items on your person and attempt to leave the store without paying for it?
Yes, I did.
Would you agree that the value of those items was less than $200?
Yes, it was.
Is it true that store employees stopped you before you were able to leave and that those items were recovered by the store?
That's correct.
To be clear, it was your intention to take those items without paying?
Yes, it was.
Thank you.
Questions from the prosecution?
None, Your Honor.
Court is satisfied with the factual basis. I'll accept your plea if I am made free voluntarily and intelligently. How long is he on probation in Eaton County?
Mr. Heather, do you know how long do you have left on your Eaton County probation?
It's probably going to be around 10 months.
10 months from today to the end?
I believe so, yes. It's just a matter of getting community service done, yes.
You said getting community service is gonna take 10 months?
Well, there's a sobriety court, we phase up, so we have to be in
Oh.
each phase for a certain amount of time. So yes, getting community
Got it.
service and then for the appropriate time.
Sentencing is October 1st at 9 o'clock in the morning. You need to check in with our probation department within the next 48 hours in person, okay?
Okay, will do.
So that they can prepare us a pre-sentence report as to how you should be sentenced on this matter, okay?
Yes, Your Honor.
You have any questions?
I do not.
Additional matters for the record, counsel.
Nothing for the people.
Nothing from the defense, Your Honor.
You're all set.
Thank you, Your Honor.
You're welcome.
Yeah, I don't know.
Who's on the tab? Who's in the Ingham County Jail? I don't know who's on the tablet. Can you hear me in the jail? Hello?
All right. We're a little hour early for Mr. Alexander. Are we ready for him?
You're logging in for whom?
Mr. Alexander at 10:30?
Okay, if you have him now, I can take him now.
Yep. Be
Sounds
just
good.
a few minutes.
Thank you. Oh, it has to be, yeah. Need to speak with them?
You get Mr. Granberry's file.
Yeah, I need the bond minutes to remove the GPS. Did I miss somebody? Is Hughes here, Irene Hughes?
Yes, he is, Your Honor. He's in the back.
On the record in the matter of the people of the state of Michigan versus Irene DeWitt Hughes, file number 24-01879, county appearance.
Hannah Almosawi on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lawrence Sutter on behalf of Mr. Hughes, who is standing to my right.
Okay, today was the date that was set Mr. Hughes for a free trial on one count of domestic violence. Is there an offer on this?
Yes, Your Honor, we have related an offer. It was a bit too late, so defense might need time to consider it. I think we should go ahead and adjourn this to a final pretrial.
Oh, give me the offer.
Schedules.
What's the offer?
Free protective status is 76948, Your Honor.
Okay. Okay, does he want a final pretrial or a second pretrial? Well, I guess a third pretrial.
Thank you, Your Honor. I have relayed the offer to him. He's requesting a final trial.
Plead guilty with no objection to 769.
August 27th.
August 27th at 8 a.m. in person for final pretrial. And the jury trial date.
September 24th at 8.
September 24th at 8 a.m.
Who is it?
Do you have any questions today, sir?
No, Your Honor.
Any additional matters?
No.
The people.
Skills and
That's
forethought.
Defense, Your Honor.
We'll get you a notice to appear. I have no clue what's happening.
Just before I leave, can anybody hear me?
I can hear you.
All right. Mr. Marion?
Okay, on the record, in the matter of the people of the state of Michigan versus Alexander Marion, file number is 24-01408, council appearance.
Kristen on behalf of the people, Your Honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Marion, who's joining us via polyphone today.
Mr. Marion, can you hear us?
Yes, ma'am.
Okay, today's the date that was scheduled for pre-trial for retail fraud second degree. How are we proceeding on this?
Your Honor, the people would like to request that we adjourn this matter for the first week of October. We currently have the defendant on multiple felony cases, and we'd like to use this time to get to
Global
some
resolution.
sort of global resolution, yes.
That's the note I had from July, so let's see, October 1st. Or after October 1st.
Our matter is the last week of September, so I believe after October 1st would be better.
I would agree, Your Honor.
October 15th at 8:30. Have any questions today, Mr. Marion?
No, Your Honor.
Any additional matters for the record, counsel?
Nothing for the people.
Nothing from defense. Thank you.
Thank you. You're all set. Mr. Marion, I don't know why it doesn't have the public defender's appearance on.
I currently have Mr. John Lee assigned to it. We're working on getting the amended appearance, but if there's none sent, I'll put a note in our files that I could run today with mine.
Yeah, I don't have any appearance at all for some reason. So that's why on the docket, it'll just show the officers name. They don't have any.
It looks like our office cleared one on June 27th, but I'll check it with my administration today to make sure that gets sent again.
Mr. White?
Yes, Your Honor.
Okay, on the record in the matter of people of the state of Michigan versus Brandon Wright, 23-03114R1. Mr. White, this was set for show cause because you owe $162. It looks like you accepted responsibility in February for disturbing the peace. I think it's in your guardian was going to be notified to make payment of the fine.
That's right, Your Honor.
Your guardian still Amanda Skeet?
Yes, it is, Your Honor.
Is she present today at all?
No, she's not.
Here. You're all set. Thank you. Yes, I'm just gonna close the file.
Still on the Zoom?
She left. Chapman, is he gonna be logged in or is he downstairs?
He's downstairs.
Oh, we can bring him up. We need to set one of these things.
Nye Johnson is right now.
On the record in the matter, the people of the state of Michigan versus Shania Johnson. And that's in file 24-01892, council appearance.
Hannah Almosawa on behalf of the people.
Jacob Riley on behalf of Shania Johnson.
Bryant seek a mental health assessment.
Yes, you did.
Where?
Access program.
To the access program? Okay, when was that?
July.
Okay, how are we proceeding today?
And there's a plea agreement that has been offered and that we have accepted.
So the offer is to amend the charge for assault and battery to disorderly jostling. No objection to sentencing under HYPA, that's correct.
That is correct, Your Honor.
Yes, Your Honor.
Want to accept that offer, ma'am? I need you to speak louder.
Yes.
Okay, raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes.
Somebody's phone ring. Is that your phone? Oh, okay. And you have an advice of rights and plea information sheet. That's your signature, ma'am? Okay, did you go over these rights with your attorney?
Yes.
You understand all of these rights? Are you willing to give up all of these rights in order to accept the offer to plead guilty to disorderly jostling? Yes, I'm asking you.
Yes.
Okay, and so that means that you have the right to be considered innocent until proven guilty. So you want to give up your right to be innocent until proven guilty? You have the right to proceed to jury trial. You want to give up your jury trial right? So that means you'll give up your right to cross-examine or question any of the witnesses that the prosecution intended to call against you. You're gonna give up your right to call your own witnesses to trial to testify or present evidence that you believe show a defense to the charge that they're bringing against you. You're gonna give up your right to remain silent at trial and not have that silence be used against you. Or you can waive your right to silence and testify at your trial if you like, but that's also a right you would have to give up if you want to accept the offer. You understand that? Anybody threatening you to get you to give these rights up? Has there been any promises in exchange for you accepting this offer? You currently on probation or parole? You understand that a guilty plea could result in a conviction that may have impact on travel or immigration status that you may seek, so you may want to go to Canada, but you could be denied entry if you get a conviction. You understand that? Okay. As to the amended count of disorderly jostling, how do you plead? Factual basis.
Your Honor. Johnson, on or about June 22nd of 2024, were you in a moving vehicle on or about Pine Street in the city of Lansing?
Yes.
And was an individual named Cheyenne Redress also in that vehicle? You entered this redress arguing?
Yes.
And it was getting heated, right? At one point, did you slap Ms. Redress with an open hand?
Yes.
that you were not acting self-defensive. Something that she invited you to do, whether she would have wanted to do. So, it would be reasonable to say that this was a harmful or offensive action to her.
Any questions from the prosecution?
Have a-
The court is satisfied with the factual basis, I can find your plea to be freely, voluntarily, and intelligently made. The matter is gonna be set for sentencing October 1st at 9 AM. You have a seat, we'll get you down to probation before you leave, so they can give me, or get you scheduled for an interview, so they can give me a report, okay? Thank you. Any additional matters for the record?
Nothing for the people.
No, Your Honor.
Thank you. You have a matter today, or are you just here to see your colleagues?
No, I'm here for Jeff.
Oh.
It's a collective effort today.
Yes. Chaplain, I sent in a motion to show.
Okay, on the record of the matter, or matters of the people of the state of Michigan versus Deontay Chapman and file number 24-01767 and 24-02009. Council reports.
Morning, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Public Defender Jake Riley here on behalf of Mr. Chapman.
Okay, today was the date that was set for pre-trial. There is a domestic violence and then a larceny, and then it looks like we have a motion to show cause that was filed yesterday by the prosecution, correct?
Yes, Your Honor. And that's specifically in the domestic violence case 24-2009 F.
Okay. and But this has a copy of the motion to show cause.
Yes, Your Honor.
Yes, Your Honor.
I emailed a copy of it to Mr. Riley last night, and I also brought an extra physical copy that I handed to Mr. Riley's colleague, Ms. Sutter, this morning.
And the concern of the show cause is the address that was provided at the time of the arraignment, is that correct?
And that he physically came to this court with the victim, which is why Ms. Wilson and Mr. Lee are both witnesses to that violation. And that is why I am handling it, not Ms. Wilson. As you might remember, Mr. Lee actually said on the record that he.
I remember. I distinctly remember. Okay, and so how did you all want to address the show cause issue?
I have no preference as to how it's handled because obviously filed yesterday. I'm not a fan of giving defense 24 hours notice, but less than 24 hours notice before hearing something. And I wasn't sure how the court wanted to handle it in regards to scheduling. So I am very much an open book in that regard to what defense and the court would like to do in regards to how to hear that.
And so we can set that, or should set that for a hearing to allow the defense counsel, which matter are you on?
I'm on the probation violation file, Your Honor.
Okay, so you're actually on both of the cases I filed today. I just called, because I only called 2 cases.
That's correct.
So you will need time to prepare for the hearing and speak to your client privately. So I can set that.
And then while we are working on scheduling for these, there is the preliminary examination for the felony matters that is scheduled for this Friday. I spoke with the victim on that matter for over 30 minutes last night. It's definitely going, it's definitely happening. Once it's found up to the circuit court, my intention is to make a global offer that includes these misdemeanor cases. If we want to reset the pretrial conferences for sometime after this Friday as well, if same time as show cause, if that works for the court. But it's always my intention when there's multiple files to try and wrap them up in one global offer.
Oh, that makes sense. I'm going to reset everything, including the probation case. August 27 at 10:30. August 27 at 10:30.
And there's one other issue on these cases.
I presume there would be.
Yep.
Let's see here. Is that August? Good. The additional matter.
Yes, Your Honor. And to be clear, in the next few bits where I'm talking, when I say victim, I mean the Kelsey Hernandez victim from the misdemeanor domestic violence file. I know he has 2, but I'm specifically talking to that one that he came to court with. After that hearing, he was then calling her from lockup, calling his family from lockup, his family get him a different number for her. And then since then, which was only a few weeks ago, from the Mason Jail, he has called that number 107 times, and he spoke with her this morning from lockup as he called her 5 times this morning. Now, people from my office called that number and spoke with her. She initially denied being her and then stopped denying it as that call went on. And then this morning, that woman is calling him Deonta over and over and over again and referencing his multiple cases. As a result, Your Honor, I would ask that pending that show cause hearing, and by the way, I will be providing recordings and logs of these to defense counsel. I would ask that his jail privileges be revoked in their entirety, including phone, e-message, and video visits. This is already shown he will try and get around them if he can. And I don't believe he should be given avenues to do so.
Mr. Rowland.
I would object to a total revocation of his contact privileges. It's possible to block certain phone numbers and so on. I certainly think that probably would be appropriate. But I hope that Mr. Chapman will be allowed to continue to speak with his family while he's in custody.
This is the allegation that he's using his family to create avenues to violate the court order. I distinctly remember him coming in with a young lady. They were very romantic with each other. And I arraigned him, remanded him. And I distinctly remember, and I could be wrong, but I believe the record reflects that I advised him on the record about the no contact and about how even if you tried to make calls from jail, that the Ingham County Prosecutor's Office listens to the jail calls. I said that. I said that. And I'm just looking at the nature of the cases. I have a DV, a larceny, and a felony that's pending. And then obviously another matter that was under my supervision. And the theme of the allegations tend to show that there's a lack of regard for court order. And that maybe Mr. Chapman thinks that he's smarter than the system. He can outsmart the system. And so because of those reasons and because of the allegations, 100 and how many calls is allegedly having occurred?
Oh, that is 107 from the Mason jail and then 5 other ones this morning. I don't remember how many were done from lockup the morning of that arraignment.
Well, that would be a violation of his bond petition. So that's a PA 53 violation on top of the show cause. He has the right to have a contested hearing on those violations. He has the right to have you represent him on those hearings at that hearing. On this file is already revoked, but he could be facing contempt of court because of those bond violations. Maximum penalty being 93 days in jail, $7,500 in fines. With that being said, I think it's in the best interest of this case and of the victim and of even Mr. Chapman at this point, so that he doesn't run the risk of accruing any more violations or potential violations, that his calls be revoked. I'm going to revoke his privileges, including visits, video, and phone calls. Only phone calls he'll be getting is from his attorney. You have any questions? That's for you, Mr. Chapman.
Yes, ma'am.
What's your question?
Not that I couldn't call my family. I never told my family to talk about
No, I'm revoking all of the calls except to your attorney. Your attorneys will get the information provided from the prosecution, which they seem to believe otherwise, based on what was stated here in the court record. Then they also have some evidence that they believe supports that you make calls even today in violation of the order which you heard me say no communication directly or indirectly. And so With that being said, no, you'll talk to your attorney until further notice. If they're not able to sustain their burden on those violations, then you can reinstate those privileges, but as of right now, those privileges are revoked.
Thank you, Your Honor.
Let's see. The bond on this one was revoked because of the concern about the other bond violation. The bond was revoked, it looks like July 23rd on this one as well. Larceny file as well, so. Continue to our next court date. Any additional matters
Not
for the
from
record
people.
today?
The defense, Your Honor.
Thank you. You're all set.
Thank you, Your Honor.
Eduardo Jimenez.
I don't think he has counsel.
I'm right here.
Sure.
Mr. Jimenez, hang tight. The prosecutor will log in and speak with you.
No worries. Thank you.
No problem.
Yes.
And then Desiree Watts is present.
Yes.
Are you ready to proceed on her matter?
One moment, Your Honor, that's all I know.
Can I proceed with Watch, Your Honor?
Just wondering if the attorney is ready on.
Yes, Your Honor, I'm ready to proceed.
Okay, on the record in the matter of the people of the state of Michigan versus Desiree Watts, file number 24-1990. Parents.
Hannah almost on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mrs. Watts, who's joining us via Zoom.
Okay, Ms. Watts, today was the date set for pre-trial. I have 2 counts of assault and battery. Was there an offer on this?
Not at the time. Unfortunately, we have not been able to get in touch with the victims on the matter. The people would like an extension or an adjournment in order to be able to draft an offer that fits what the victims agree to.
Okay, so you want a second pre-trial?
Yes, please.
Your Honor, if I may.
Yes.
I'd request a final pretrial. I think that would give us sufficient time for the state to reach out to any witnesses in this matter, as well as continue the case moving forward while we.
I'm gonna set it for a second pre-trial at this time. That there's time. If they can make contact to extend an offer and you can speak with your client versus a final pre-trial. That's September 3rd at 8:30. Any additional matters for today's record?
Nothing further for the people, Your Honor.
Looking for the time. Thank you. You're all set, Ms. Watts.
Okay, thank you, Your Honor. Y'all have a blessed day.
Same to you. Let's see. John Shannon. Oops. I pronounced that right.
Yes, I'm here.
Okay.
And yes, I am.
To me. Oh, let's see. Where is the? Oh, his GPS was shut off. Okay, on the record in the matter of the people of the state of Michigan versus Tajon Shannon, file number 24-02060. Council appearance.
Hannah Almost on behalf of the people, your honor.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter, on behalf of Mr. Shannon, who's joining us via Zoom.
Okay, is his tether back on?
Yes, Your Honor. Your court staff has some communication with me regarding some payments. I reached out to him, he reached out to GSG and advised that he paid the balance on that.
I see where there was a warrant, bench warrant that was generated, but doesn't look like it was entered or signed. Someone wanted the signature.
I think your court officer reached out to me telling me that if he was unable to pay the balance with GSG by the time, I can't remember the exact time in the email, but that a bench warrant would enter. She then got back in contact with me to see if that was done. I advised her that he had told me it was, so I believe it wasn't going to be.
But it's not even so. I don't see where it's been, I don't see, is it entered? Is it warrant? Because
No, I think she
there's no
just
signature.
generated.
Okay, well,
I've always paid my tether.
Just 1 second, Mr. Shannon.
Oh, I'm sorry.
I'm just trying to follow up on the note that there was a warrant, so I'm trying to figure out why. And there was one generated, but it doesn't look like it was entered, so I'm just trying to figure out on our end what needs to be done, not indicating. Your attorney indicates your GPS is back on. We did get notice that your GPS was shut off. But it looks like you paid it or took care of it. So there's a assault or assault and battery. How are we proceeding on that?
Your honor, the people do not have an offer at the time as you have not been able to make contact with the victim. We request a second pretrial if the court will allow it.
And Your Honor, I would again request that final pretrial, so this case is continuation move forward. She's on bond. I think that time allows for the state to reach out to any witnesses in this case.
I'll grant the request for second pretrial. September 3rd at 8:30. September 3rd at 8:30. Any additional matters for today's record?
Nothing further, your honor. Thank you.
Nothing further. Thank you.
You're all set for today, Mr. Shannon.
Okay, thank you.
You're welcome. See Kevin McKenna.
Yes, Your Honor.
Okay, I was, there was someone sitting up there. That's fine. Okay.
This is Kevin.
And we're ready on him. On the record in the matter of the people of the state of Michigan versus Kevin McKenna, file number 24-01386.
Hannah Almost on behalf of the people.
Jacob Riley on behalf of Mr. McKenna.
Okay, Mr. McKenna, today was the date we reset for your pretrial. Looks like negotiations were continuing at our last pretrial. How are we proceeding at this time?
Your honor, the people have offered Mr. McKenna a plea offer in which he would plead guilty to operating while intoxicated, and we would dismiss the operating with a high VAC. And it seems as if that he is willing to accept this plea offer.
Mr. Rowley.
That is correct, Your Honor. And the people with review.
Oh. That's not how you want to proceed today, Mr. McKenna?
Yes, Your Honor.
Raise your right hand. You solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury.
Yes, Your Honor.
Put your hand down, sir. This is an advice of rights and plea information sheet. This lists all of your rights that you would need to give up if you want to accept the plea offer. Did you read this?
Briefly, yeah.
Okay, but did you go over each of these rights with your attorney?
Yeah. Yes, Your Honor.
Why did you delay your answer? You can't remember?
He pretty much summarized it and I know what it says. I
Okay.
give up all my rights if I take the plea.
That's correct. You're not giving up. Well, you're giving us specific rights, not all your rights. Let's see here. Did you sign this?
Yes, Your Honor.
Okay, and so I'm gonna give this back to you. You're gonna read it. We're off the record. You can go speak with Mr. Newman.
You put us in a breakout room?
Yes.
Thank
Did we see Joshua Rhodes?
I don't know yet this morning. Your Honor.
There's somebody else in custody.
Yes, there are two other people in custody.
Downstairs?
Anthony Shearer and Alexander Marion.
You did, yes.
Mr. Jimenez, can you hear us?
Yes, can you guys hear me?
I can hear you. On the record in the matter of the people of the state of Michigan versus Eduardo Jimenez de Santiago, phone number 24-01586 SM, council appearance.
Sakina Almonsawi on behalf of the people.
And Mr. Eduardo Jimenez de Santiago is present via Zoom without attorney. This is an unlicensed dog matter. How are we proceeding today?
Your Honor, Mr. De Santiago has provided me with a new license, an updated license. He is currently sending it to my email, so we will have the proof within the next couple of minutes. But the people would like to proceed with dismissing this case against Mr. De Santiago.
Okay, the case is dismissed. You're all set, sir.
Thank you, I appreciate it.
You.
Have a good one, guys.
Same to you. We're back on the record in the matter of the people of the state of Michigan versus McKenna. Okay, and so I was going over your rights. You are still under oath. Let's see here. So you reviewed your rights at this time.
Yes, Your Honor.
Okay, so you understand that you're presumed to be innocent until proven guilty?
Yes, Your Honor.
Okay, and so you have the right to require the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You can remain silent by right and not have silence be used against you, or you can waive your right to silence and testify at your trial if you like. You have the right to call witnesses to testify at your trial on your behalf, or you can present evidence that you believe show defense to the charge being brought against you. And you have the right to see, hear, or question any other witnesses that they intend to call against you. You want to give up all of those rights? Is anybody making any threats to you to get you to do that?
No.
Any promises being made in exchange for you entering a guilty plea today?
No, Your Honor.
Are you currently on probation or on parole?
No.
And you understand that a guilty plea could result in a conviction that you may need to report to your employer.
Yes, Your Honor.
A guilty plea could have impact on where you can travel, such as if you wanted to go to Canada, they could deny entry, or it could have impact on immigration status that you may see. You understand that?
Yes, Your Honor.
As to account 2 of operating while intoxicated, how do you plead?
Guilty, Your Honor.
That's because you believe you're guilty?
Yes, Your Honor.
Factual basis.
Mr. McKenna, on or about October 13th of 2023, were you operating a motor vehicle near the intersection of Cedar and White Riley Street in Lansing?
Yes, sir.
Is that in the city of Lansing, in the criminal state of Michigan?
Yes, sir.
Had you consumed some alcohol prior to driving on the day?
Yes, sir.
Did you have an accident?
Yes, sir.
And did you then have contact with police afterward?
Yes, sir.
Did those police officers conduct field sobriety tests?
Yes, sir.
Is it true that after conducting those tests, they felt that a test was necessary? And they asked you to make a breath test? After the breath test, they asked you to consent to a blood test. You agreed to submit your blood test.
Yes, sir.
And is it true that you then were taken to Sparrow Hospital, McLaren Hospital, where your blood draw was conducted?
Yes, sir.
And you agree that the result of that blood draw and subsequent testing of the blood showed that the blood alcohol level was supposedly below 0.0.
Yes, sir.
That's factual basis.
Any questions from the prosecution?
No, Your Honor, thank you.
Court is satisfied with the factual basis of how your plea to be voluntarily and intelligently made. The matter will be scheduled for sentencing October 15th at 9 a.m. You'll go down one floor to probation so that they can prepare you for your pre-sentence interview, okay?
Yes, Your Honor.
Do you have any questions today?
No, Your Honor.
Okay, any additional matters for the record?
Nothing further, Your Honor.
No, Your Honor.
Thank you. You're all set. Hang tight, we'll get you downstairs. Or actually, if you want to go down there now, they can come up and get the file.
Fifth floor?
A fifth floor, you'll go down one floor, and when you get off the elevator, you go to your right.
All right, thank you.
You're welcome.
What was the sentencing date?
October 15th. Nine a.m.
Your Honor, Mr. Shearer was sent back to ICJ. He's not downstairs. It was apparently because of his behavior this morning.
Oh, well, we'll be set.
Thank you.
August 13th. August 13th at 1:30.
I apologize. He has another, he's a 55th district court date that same day.
Oh. August 27th.
Apologize. Can you repeat the time one more time?
1:30.
1:30. Thank you very much.
No problem. Sorry, Molly, is that one? And no word from Rhodes. Okay, on the record in the matter of the people of the state of Michigan versus Terrence Hawley, and file number 24-01357.
And on behalf of the people, Your Honor.
Jacob Holly, on behalf of Mr. Holly.
Okay, today was the date that was set for a pre-trial, and then there's a P53. See, for a domestic violence, and then we have a pending violation from June 20th, and then there was one from June 24th that he experienced. I'm sorry, July 24th.
Your Honor, the people were requesting some sort of adjournment pending global resolution due to the fact that the July 24 felony that you have on file is related to this victim on our DV case. And with the PA 53 violation, it has been bound over as well. So Attorney Pfeiffer is on it, and we wanted to see if you would allow us sometime until the end of October so we can figure out what's going on with the rest of the cases, especially the ones that include this victim.
Yeah, I'm actually reading this report. Is after arraignment first. I have a police report here. The date of the report is for June 27th. I don't see a report for. June 27th, 2024, approximately 9:17 p.m. And the allegations are that you violated your bond conditions on this file by committing the following. It says not to commit a crime while released, not to harass, intimidate, beat, molest, wound, stalk, threaten, or engage in other conduct that would place the following persons or the child of the following persons in fear for bodily injury, that being your spouse, former spouse, individual who you had a child in common with, a resident or former resident of your household. Not to harass, assault, intimidate, beat, molest, wound, or threaten a person by the name of Jessica Redmond. Not to have contact directly or indirectly with Jessica Redmond, and not to be within 1,500 feet of wherever she lives, works, or goes to school. And so the allegation is that you violated those conditions. So you have the right to have a contested hearing on that violation. You have the right to be represented by your attorney. If you're found to be in violation of your bond conditions, your bond can be revoked pending the ultimate resolution on this matter. Or you also can be found in contempt of court for violating the court order. Do you understand that?
I did 30 days for that already.
30 days for what? I just arraigned you on this. You haven't even arraigned on this. So this is the third violation in this file. So you're talking about May 21st, 2024. You were arraigned on a violation. You pled guilty. You were sentenced to 30 days Ingham County Jail with credit for 7 days. And I have another violation that we received on June 20th. You were arraigned by magistrate no more on June 20th. You pled not guilty. We've not had a hearing on that, nor have you entered a guilty plea. Then I just got another one that I just arraigned you on. You understand now? The 3 different dates are being alleged as to violations, okay? It's a alleged violation from June 27th, alleged violations from June 19th, and you've already resolved the violation from that. How does your client want to proceed on the violations? He wants a hearing?
Yes, Your Honor. Yes, these violations clearly are closely related to some pending penalty cases. I would ask that these matters be set out so that some progress can be made on these penalties, which are currently in circuit court.
That's what you were indicating. He has a matter that's already bound over in circuit court. And what's going on with that?
So just this week, we had something in screening that Attorney Pfeiffer is working on. It is a CSC involving the same exact victim that we have on this case. And so we were trying to see if we can have some form of, global resolution.
Sir, why are you talking on my record? Why are you doing that? No. If you can't be quiet, I'll send you back downstairs. We can hold this hearing without you. Control your mouth. Let her speak. Thank you. Continue, counsel.
Yes, Your Honor. So that showed up just this week. I'm pretty sure that it's not even on your end, and that is why we're asking that we have an adjournment to somewhat the end of October so that we can look into the case, figure out what's going on, get in touch with the victim. And then regarding the PA 53 that we have on here from June 19th, the defendant was bound over on only one of the charges in that matter. And so I doubt he's willing to plead guilty to any of that at the time. So we would also leave that to a later date, hopefully.
So he has 2 files in felony or at circuit court right now?
Yes.
Okay, and then this matter, then a potential new one.
Yes, and now with the one that just bound over, I'm guessing that one as well. Other than the felony from before, and then the one that just showed up in the screening.
Got it, okay. So we need to set these out, post what's going on there, which is when?
Hopefully end of October, I've been told.
Resolution in October, except this. Okay, yeah, what do you want it set for in October? Pre-trial?
Yes, let's try and keep it as is for the time being. I think that the attorneys will deal with it in felony court. Probably use it as some form of global resolution.
Okay, is he on probation before driving truck still? No.
Yes.
Okay, give me a date. October 29th at 10. October 29th at 10. And do you have any questions from the court? I'm not putting anything on you. I have zero idea. I have no idea about the CIC. They are the screeners. And there, if one is issued, then you'll be notified and you'll be advised by your attorney. But she's just mentioning that there is a screening going on for a potential CSC. Okay? Do you have any questions for the court, though? Any additional matters for the record?
Nothing for the people, Your Honor.
No, Your Honor.
You're all set.